that everyone does understand that the presentation and the materials that I have provided for you today are for informational purposes only and should not be used as a substitute for legal advice on a particular matter. When we talk about medical marijuana, as you will see through the presentation here, it's very uniquely state law issues as opposed to federal law, because marijuana is still considered an illegal drug throughout the United States. And it may make you question is why do we talk about the legality of marijuana in the various states, and I will talk about why it is quote-unquote legal in some states, despite the fact that it is illegal across the country. And of course, because it is very uniquely state law, for this reason, and due to the format, you always do want to, format of this webinar, you always want to make sure that you get legal advice on any particular matter dealing with medical marijuana. Move over here, a couple of slides here. And let's first of all just talk about what is marijuana, the common forms of marijuana. It does come in a lot of forms. It's not just the cigarette that you see in the media or the movies. It does come in a lot of different forms. It is a green, brown, or a gray mixture of dried, shredded leaves, stems, seeds, and flowers of the cannabis plant. Of course, marijuana has its origin, despite its form, in the cannabis plant. It does contain more than 400 chemicals, buds that have higher THC, and that is the main psychoactive ingredient of marijuana. It is a mind-altering chemical in marijuana, and if they do have those high THC content, of course, that is where you see the altering chemical that does, alter our mind and how we do react to certain situations. Marijuana is hashes or hash. It is the pure resin that is separated and collected from the flowering tops of the cannabis plant. Depending on its purity, and marijuana does have different levels of purity, it will vary in color from golden brown to black, and it can be smoked, it can be eaten, or it even can be vaporized. There is hashish oil that is produced by removing the cannabinoids from the plant material with the liquid. In the U.S. and throughout all 50 states in the United States, marijuana is a Schedule I drug under the Controlled Substances Act. There are 5 schedules under the Controlled Substances Act, and Schedule I, which includes marijuana, also includes heroin, LSD, and the like, what I typically refer to as our street drugs. Marijuana is considered to have highly addictive qualities and no medicinal purpose in the United States. Despite some efforts to remove marijuana from a Schedule I drug, the government has refused to remove it from a Schedule I drug, meaning that it is still considered illegal in all 50 states. We have our Schedule II drugs, which include things like methadone and the like. Those drugs are also considered to be highly addictive, but they are considered to have some medicinal value within our country. And the Schedule III, less addictive than Schedule II, but still addictive drugs, again having more medicinal value, going all the way down to Schedule V drugs. Marijuana has been encouraged or suggested to the government to remove marijuana from Schedule I into possibly a Schedule II or III drug, but as I said, the United States government, the DEA, has refused to remove it from the Schedule I status under the Controlled Substances Act. So marijuana basics here, it is usually smoked as a cigarette, which they typically refer to as a joint. A cigar might be referred to as a blunt through a water pipe or on. It can also be orally ingested, such as baking it into foods, boiling it in water to make tea, or in a pill form. Now that Marinol is a pill form of marijuana, and it is not a Schedule I drug. It is a Schedule II drug, meaning that it can be prescribed in the United States as a Schedule II drug throughout all 50 states, and I'll talk about the difference between that and the typical marijuana that we think about. Marijuana can also be heated with a liquid until the active ingredients do turn to vapor, which can be inhaled. And a big problem with marijuana is it frequently can be laced with or combined with other drugs, such as PCP. So people who do buy marijuana on the streets sometimes are running the risk that the marijuana may not be pure, if you will, and may be laced with other drugs that can be problematic. Now, there are other forms. There are currently 3 cannabinoid drugs that are available for prescription use under federal law. As the Marilon, as I said, I think I said Schedule 2, but it's a Schedule 3 drug, and it is a sesame oil suspension of the dronabinol, and it's capsulated in a gelatin shell. It did receive FDA approval in 1985 for the treatment of nausea and vomiting that is associated with chemotherapy, and as an appetite stimulant for the treatment of AIDS-related weight loss. There's also something called Syndrose, which is a Schedule 2 drug. This is a liquid oral form that has been approved for treatment of chemo-induced nausea and vomiting, and also for AIDS-related weight loss. And then we have the Nabinol, which is a Schedule 2 drug that is sometimes prescribed for treatment of post-traumatic stress disorder and headaches due to medication overdose. So looking at some of the horizons, the FDA did approve the use of Epidiolex in June of 2018. And what is this? It is a liquid oral form of the cannabinol for the treatment of Dravet syndrome and Lennox-Gastaut syndrome. Despite its approval in June of 2018, the DEA has not yet assigned this particular drug to a schedule, and it is expected to be available for use sometime this fall. And again, that would be available on a federal level, so it would be legal to take in all 50 states. Now, there are some slang or some street names for marijuana that you need to be aware of, sometimes called pot, herb, weed, Mary Jane, grass, chronic, keef, which we reefer a lot, skunk, boom, gangster, and there are really more than 200 names assigned to marijuana, those slang or those street names. There are also different strands of marijuana that may have their own brand names. So what are some of the side effects of marijuana? And you as an employer, this is where you need to be concerned, because even if marijuana is quote unquote legalized in the state where your organization operates, you do have to be concerned about the side effects of marijuana, just like you would have to be concerned about the side effects of any prescription drug that someone may be taking, or the side effects of even an over-the-counter drug such as Benadryl. You need to be aware of these side effects, because if someone is taking it, even taking it legally, if the side effects of the drug does cause a danger to themselves or others, obviously as an employer, that is something that you do need to concern yourself with. Some of the side effects of marijuana can include paranoia, even short-term memory loss. Of course, somebody can become extremely relaxed. One time it was described to me as, you just don't care. You have lost or you just don't have the ability to care about things, which is one of the reasons why people like to take marijuana, because it does, if you will, relieve them from some of their problems in the world, if you will, even if it's just for a short period of time. There's also a heightened sensory perception. They see colors in a brighter status. They may engage in laughter. They have an altered perception of time. One of the most common side effects in marijuana is it has an increased appetite, and it can also cause a euphoria, again, making them at risk if they're under the influence at work to their safety or the safety of others, depending on the position that they may hold in your organization. Now, the effects do vary, just as any other drug, does affect individuals differently, depending on a lot of variables. Of course, you have your individual physical characteristics, someone's metabolism, their weight or their age, the dose, the quantity, and the frequency of which they take it. We know just like alcohol and the other drugs, that people will build up a tolerance, and those who build up a tolerance after using a very significant period of time may have to use more of the drug to feel the same side effects that they once felt with just a very minimal amount of the drug. The route of the administration can also vary the effect, of course, the experience of the user, and of course, if the individual is using any other substance use and the like, and then combining that with this marijuana use. So how common is it? And we certainly have heard about marijuana, much more so in the last 10 years or so. Probably individuals were already using it, but they weren't as open about their use of it, of course, because of the fear of prosecution for criminal activity and the like. But it is estimated that over 111 million Americans have tried marijuana at least once in their life. and an estimated 2.4 million Americans have used it for the first time in 2012, which was when we first started seeing marijuana become legal in various states in the United States. Of course, one of the things that we're always concerned about is when someone is under the influence of any drug that may be mind-altering. And of course, we think about driving or operating in heavy machinery. And this was a chart that was put out testing where drivers who tested positive for marijuana only, meaning that they had no other drugs in their system other than marijuana, and they were involved in fatal crashes. And you can see the number of drivers that have been tested positive for marijuana only have increased over the years. In 2006, we had a number of drivers of 21. In 2011, going up to 52 drivers who had tested positive for only having marijuana in their system. So you would think if that's the case, if marijuana is such a mind-altering drug, maybe it shouldn't be legal in any state. But there are obviously people who believe that marijuana does not have the same dangers associated with heroin or LSD that are other Schedule I drugs. There was a 2016 study that found significant drops in violent crime in states that have legalized medical marijuana. A 2017 study similarly found that the introduction of medical marijuana laws had caused a reduction in violent crime in American states that border Mexico. They no longer have to smuggle this marijuana across the border and the like. A 2013 study found that medical marijuana legislation was associated with 8 to 11% reduction in traffic fatalities. And several studies have found that there has been a decreased rate of opiate use in states that have legalized marijuana use. And of course, we know that the opiate addiction within our country is considered, one of the most highly, addictive drugs in our society, and an extreme problem within the United States. So what is the impact of marijuana in the workplace? Well, some studies have linked workers' marijuana smoking with increased absences, tardiness, of course, accidents, and of course, when they have been involved in accidents in the workplace, that is going to lead to a workers' compensation claim, and also has shown that there is increased job turnover for individuals who are using marijuana. And of course, that is from an NIDA research report that came out in July of 2012. So let's talk about the quote-unquote legality of marijuana. Now, why have states been able to legalize marijuana use, whether it be for medicinal purposes or for recreational purposes? Well, this is in large part despite the fact that it is a Schedule I drug. The United States government says that it recognizes about 98% of all arrests for marijuana use have historically been done by the states, and the federal government simply decided that it did not want to expend its sums or the budget that it had on prosecution of marijuana use. And after the DEA made that announcement that it was not going to budget for enforcement of marijuana as a Schedule I drug, that's when you started seeing all of the states coming up and legalizing medical marijuana. Currently, there are 31 states plus the District of Columbia, Guam, and Puerto Rico that permit the use of marijuana for medical purposes. Now, in these 31 states, you can't just use it for any medicinal purpose. These states have very restrictive reasons why someone might be able to use marijuana, and I'll go through those reasons here shortly. But California was the first state to pass a law legalizing medical marijuana in 1996. Just 5 years ago, that number was at 21. Now we're up to a whopping 31 states. So over half of the states in the United States do allow for marijuana use for medicinal purposes, with very few allowing it for recreational purposes. So here's our map. If you look at our map here, the dark green on our map here, medical marijuana, this is where no doctor's recommendation is required for the use of marijuana. And of course, this is where we do have the allowance for recreational marijuana. In our lime green, this is where you do have to have a prescription to use marijuana marijuana. Grayish green, these are states that will allow some THC content, and this is where usually we're looking at the Schedule 2 or 3 drugs as opposed to the Schedule 1 drug. And in the gray areas, these states prohibit all use of marijuana, whether it is for medical purposes or recreational use. So let's look at some of the states. There are a number of states that allow marijuana for the treatment of cancer, HIV or AIDS, multiple sclerosis, and epilepsy treatment. And this is probably the most common reason why marijuana is allowed to be prescribed in these states. There is a large number of these states that do allow for marijuana for cancer or HIV. It does include Alaska, Arizona, Arkansas, California, Colorado, Connecticut, Delaware, your District of Columbia, Florida, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, also Minnesota, Montana, Nevada, New Hampshire, New Jersey, New Mexico, New York, North Dakota, Ohio, Oklahoma, Oregon, Pennsylvania, Rhode Island, Vermont, Washington, and West Virginia. And then we have other states that say, well, we're going to allow marijuana, but we want it for specific purposes here. These are states that will allow it for Parkinson's disease. These do include California, Connecticut, the District of Columbia, Florida, Illinois, Maine, Massachusetts, New Hampshire, New Mexico, New York, North Dakota, Ohio, Oklahoma, Pennsylvania, Vermont, and West Virginia. And then we have states that do allow it for marijuana to be prescribed for Crohn's disease. This includes Arizona, Arkansas, California, Connecticut, the District of Columbia, Florida, Hawaii, Illinois, Maine, Massachusetts, Michigan, Minnesota, Montana, Nevada, New Jersey, New Mexico, New York, North Dakota, Ohio, Oklahoma, Pennsylvania, Rhode Island, Vermont, Washington, and West Virginia. And then we have glaucoma, post-traumatic stress disorder, your wasting syndrome, seizures. All of the states that I had indicated earlier will allow marijuana use for glaucoma, with the exception of Delaware and West Virginia. All of the states that I just discussed will allow marijuana use for post-traumatic stress disorder, except Alaska and Nevada. And all states I just discussed here will allow marijuana for wasting syndrome, except Florida, New Jersey, and Pennsylvania. And then all of those states that I listed on the previous slide will allow marijuana use for seizures, except for New Mexico. Now, there are some states, as I said, that will allow marijuana use for what was under the Schedule 2 and 3 drugs, but do not allow it as a Schedule 1 drug. And this is where we have the marijuana that's been taken that is in a very low THC, and the marijuana is taken in a pill form. These states have very restrictive laws that do limit the allowable concentration of THC, which is, again, the main psychoactive component of the cannabis plant. Of course, the purpose of these laws is to allow for the use of a cannabidiol, which is a non-psychoactive cannabinoid that has been shown to be effective in the treatment of seizure disorders, particularly in children. So what are these states that do allow the pill form of marijuana, if you will? This does include Alabama, Florida, Georgia, Iowa, Indiana, Kentucky, Mississippi, Missouri, North Carolina, Oklahoma, South Carolina, Tennessee, Texas, Utah, Virginia, Wisconsin, and Wyoming. Now, in each of these states, because they're allowing it as a low THC, which is a Schedule 2 and 3 drug, these drugs would be legal both under a federal and state level. And that is important to distinguish here, as you will see in the presentation a little bit later when I talk about the Americans with Disabilities Act. The ADA does exclude anyone who is currently engaging in the use of illegal drugs. And as I said, marijuana being a Schedule 1 drug is illegal. If someone is taking a Schedule 2 or 3 drug and they're taking it as prescribed, they would not be excluded from coverage under the Americans with Disabilities Act. So we talked about the legalization of marijuana in recreational. In 2011, no states permitted marijuana use for non-medicinal purposes. Now, currently, there are 10 states, including the District of Columbia, that do permit it. It started with Colorado and Washington in 2012. Vermont this year became the first legalized recreational use through its state legislature. Hot off the presses, this just came in this past week. New York is looking into possibly passing law that would allow for marijuana use for recreational purposes. Just this week on August the 2nd, 2018, New York Governor Andrew Cuomo did announce the creation of a work group that is designed to begin drafting legislation for a re-regulated adult use marijuana program. So it's looking into should they be legalizing it for recreational purposes. Some of the key topics that the legislation is going to address, according to the announcement, will be who will regulate the manufacturing, the distribution, and the retail sale of marijuana. How will the product be taxed and at what levels? Where will the revenue from the regulating and taxing go? And how will the criminal penalty statutory scheme change in New York should they happen to pass legislation that would allow for marijuana use as a recreational drug, as opposed to merely a drug for medicinal purposes. So let's talk about the Department of Transportation. And as I said, we have 31 states that now say that you can prescribe marijuana for medicinal purposes. Of course, if you have employees who are subject to the Department of Transportation regulations, the Department of Transportation Office announced on December 3rd, 2012, that any state initiatives that are designed to allow marijuana, whether for medicinal or recreational purposes, that it is going to have no bearing on the Department of Transportation's regulated drug testing program. So the DOT's drug and alcohol testing regulation that is found in 49 CFR Part 40, it does not authorize the use of Schedule I drugs, including marijuana, for any reason whatsoever. So if you do have employees who are subject to Department of Transportation regulations, even if they have a prescription for marijuana use, they will not be allowed to drive any commercial vehicles if they are taking marijuana, because according to the Department of Transportation, it is still an illegal Schedule I drug. So what happens with regards to your medical review officers? An MRO is not going to verify a drug test negative based on information that a physician recommended that the employee use medical marijuana. So what we typically have is when someone is taking Schedule II through a 5 drug and they're taking it as prescribed, if it's within the limits of the prescription, it is, the therapeutic limits, the MRO is going to tell you that they tested negative for those drugs, even drugs like methadone, which I know that concerns a lot of employers, methadone being highly addictive, but it's a Schedule I drug that is typically prescribed for individuals who have a history of heroin addiction. It assists them in the withdrawal of heroin and lowers their desire to take heroin. Despite the fact that methadone can create some safety issues if someone is taking it within the limits of it's being prescribed, then the MRO will notify you that they tested negative for that particular drug, even if you are testing for it. But of course, if they're taking it more than as prescribed, that does mean that they are engaging in the illegal use of drugs. If they're not taking it as it is being prescribed, that's when the MRO will tell you that the individual had tested positive for the drug. But when it comes to marijuana, even if they're taking it as prescribed, the MRO is required to tell you that they tested positive for the drug because it is a Schedule I drug. So we talked about federal law versus state law. Of course, accordingly, federal law is at odds with state medical marijuana law, and this does have some significance. Employees may be protected from arrest, discharge. You may even be limited in your ability to terminate employment, penalties, threatening, etc. under state law, but they do not apply if the federal law applies with regard to things like CDL, DOT testing, and the like. So we talk about the criminal ramifications, and this is where I've talked about that, again, it is a Schedule I drug, and therefore, technically, the federal government can arrest someone for using marijuana, and federal law does trump state law. The only time state law can trump federal law is when state law provides greater rights than someone is provided on the federal level. So, but with this regard, being a Schedule I drug, it is still considered to be illegal. However, the Department of Justice emphasized on April 23rd of 2012, stating that it would not focus its limited resources on seriously ill individuals who use marijuana in compliance with state law. The Department of Justice does maintain the authority to enforce the Controlled Substances Act vigorously against individuals and organizations that participate in unlawful manufacturing and distributions, even if such activities are permitted under state law. Of course, that was in 2012, when we're now into 2018. Is that still the position of the federal government? It has been announced in the Trump administration that they may take a new look at the priorities of the Department of Justice, and the Department of Justice may back off of its, of its stance that it would not use its limited resources to enforce marijuana laws on a federal level. With that said, there was a bill that was passed by Congress prohibiting the budgeting prohibiting any line item for enforcement of marijuana through its budget, through the Department of Justice's budget. So here we talk about former. Of course, this was the Obama administration. We had the Attorney General Holder. This is where the Attorney General Holder stated that the Justice Department will not attempt to challenge state laws that allow for the medical and recreational use of marijuana as long as the drug sales do not conflict with 8 new federal enforcement priorities. These enforcement priorities do include the distribution of marijuana to minors, and sales that assist or act as cover for trafficking operations. So as long as it is being used as a prescription drug or just, in your home as a recreational drug, this is where, under the Obama administration, the Attorney General Holder stated that they would not challenge the states that did want to legalize marijuana, if you will. So presently federal authorities, the U.S. Justice Department, is seeking to abolish the current policy prohibiting the use of federal funds to prosecute medical marijuana patients and physicians. So what we could have is a complete change in the current stance where the federal authorities could seek to enforce the Controlled Substances Act, again with federal law classifying marijuana as a controlled substance on Schedule I. And this was from a Washington Post article quoting Jeff Sessions, where he did ask Congress to let him prosecute medical marijuana. Currently, that is the Department of Justice does not have that authority within its budget. So federal law is at odds with public opinion. We've certainly seen public opinions thinking that marijuana is no more harmful than alcohol use, and marijuana does have a lot of, pluses, if you will, with regard to treatment of various illnesses like cancer, seizures, and the like, as we've seen these states that are now certainly recognizing that there is some support for marijuana treating various illnesses. There was an April 2017 poll noting that medical marijuana is incredibly popular. It is supported by a whopping 94% of the public, and nearly 75% of the public disapprove of federal government that enforces federal laws in states that have approved medical marijuana use. Now let's talk about the Americans with Disabilities Act. I think we know the ADA that was passed during the George Bush administration ultimately amended. We have the Americans with Disabilities Amendments Act, and under the ADA, individuals who have a physical or mental impairment that substantially limits a major life activity must be provided with reasonable accommodations that would allow them to perform the essential functions of their job. A number of the conditions that I talked about earlier, where marijuana has been legalized for medicinal purposes, would fall as a disability under the ADA. Things like cancer, Parkinson's disease, epilepsy, those things are clearly possibly, almost probably, will be considered a disability under the Americans with Disabilities Act, meaning that if they are a disability, then you have to provide those reasonable accommodations, only subject to whether someone poses a direct threat to their safety or the safety of others. But the ADA does specifically exclude anyone who is currently engaging in the use of illegal drugs. That is defined, again, any use of Schedule I drugs for whatever purpose, or any use of Schedule II through V drugs and taking it not as prescribed. Those individuals are specifically excluded from coverage under the ADA, meaning there is no duty to provide any reasonable accommodation to these individuals. So the question comes up in these states that have, legalized marijuana use for medicinal purposes. If someone is taking it as prescribed, are they excluded from coverage under the ADA? A court in California, Oregon, and Colorado all addressed this issue and specifically stated that it had to be legal under federal law in order to, for the individual to be covered under the ADA. And since marijuana is a Schedule I drug, any use of marijuana, even if it is being taken as prescribed, would exclude the individual from coverage under the ADA, meaning there is no duty to accommodate their use of marijuana. Now, you may have comparable state laws that, again, may provide greater rights under the ADA. And there are a number of states that do have comparable disability laws similar to the ADA, and in those states there may be coverage under the state law when there is not coverage under the Americans with Disabilities Act. So let's talk about, can you terminate someone or refuse to hire someone because they are taking marijuana, even if they're taking it as prescribed? 9 states that do have medical marijuana statutes are silent on employer or employee rights. So even if it's being prescribed, within the bounds of state law, these 9 states don't have any, don't provide any guidance on whether you can terminate someone for being under the influence or taking medical marijuana. And let me back off of that just a little bit. You do have a right as an employer to always ensure that someone is not under the influence of any drug, whether it's legal or illegal, while at work. Just like alcohol is a legal drug, you certainly have a right as an employer to prohibit someone from being under the influence of alcohol. But part of the problem, we talk about termination or refusal to hire. Let me focus a little bit about refusing to hire someone because they test positive for marijuana. Do keep in mind that when you're doing your pre-employment drug test, you are testing for metabolites. You're not testing for what's in their actual bloodstream. And marijuana can be in the urine for a significant period of time past when someone has smoked, usually somewhere from 2 to 3 weeks after they have taken marijuana. So the question does arise, why would you have any concern about someone who has tested positive for metabolites? Because that is not necessarily indicative of whether they will report to work under the influence. And there are studies, both pro and con, as to whether that is indicative of someone who may actually later report to work under the influence. So do think in that terms about if you hire someone. But as I said, these 9 states do have medical marijuana statutes, again, that are silent. 2 states have medical marijuana statutes that do address employer-employee rights, but then they're unclear on an employer's ability to terminate. 2 states do have medical marijuana statutes that explicitly grant employers the right to terminate as they see fit. 5 do have medical marijuana statutes that expressly prohibit employers from taking any adverse action. And then 2 other states have medical marijuana statutes that classify an employee's underlying condition as a disability. And this is where you have states that have comparable disability laws, very comparable to the Americans with Disabilities Act. So these states that do classify the individual as a disability, they would require that same analysis that you are required to do under the ADA in determining whether you can whether you are required to allow them to take marijuana as a reasonable accommodation, and again, only restricted by whether their use would cause a direct threat to either their safety or the safety of others. And do keep in mind that when we're talking about whether something does cause a direct threat to someone's safety or the safety of others, we are looking at objective medical facts to make that determination and not on stereotypes and the like. So let's talk about the 9 states that are silent on employer or employee rights. These states of California, Colorado, and Washington say it's okay to terminate someone who is taking marijuana even for medicinal or recreational purposes. It's likely okay to terminate in the District of Columbia, Louisiana, Maryland, Michigan, and New Jersey. It's a close call, but it's likely not okay to terminate in Massachusetts, and I'll talk about that case here shortly. So the 2 states that do address employer-employee rights, but they're unclear as to the right to terminate, do include Connecticut and Illinois. It's likely not okay to terminate in either state, especially Connecticut. If you do operate in Connecticut, that state statute states that no employer may refuse to hire a person or may discharge an employee solely on the basis of the person or the employee's status as a qualifying patient. Nothing in this subdivision shall restrict an employer's ability to prohibit the use of intoxicating substances during work hours, but as long as they're using outside of work, you cannot refuse to hire them and you cannot discharge them. Illinois states that no employer may penalize a person solely for his or her status as a registered qualifying patient, and that means someone who is taking marijuana for medicinal purposes and taking it in accordance with a prescription. 2 states that address employer rights, but it's unclear as to the right to terminate. Here, one stating that nothing in this act shall prohibit an employer from enforcing a policy concerning drug testing, zero tolerance, or a drug-free workplace, provided the policy is applied in a non-discriminatory manner. And another saying nothing in the state shall limit an employer from disciplining a registered qualifying patient for violating a workplace drug policy, and nothing in this act shall be construed to create a defense for a third party who has failed a drug test. So 2 states that explicitly grant employers the right to terminate do include Florida and Ohio. 5 states that do explicitly prohibit employers from taking adverse action for someone who is taking marijuana for medicinal purposes would include Arizona, Delaware, Maine, Minnesota, and Pennsylvania. We talk about the 2 states that classify an underlying condition as a disability. And again, this is very similar. These states typically do have a state statute that is almost word for word as written under the Americans with Disabilities Act, meaning that you must provide reasonable accommodations to those individuals who have a physical or a mental impairment that substantially limits a major life activity. So these states, they look at marijuana use, and they're saying, well, these individuals, you have to look at them as being disabled, and you have to go through the same analysis as to whether you must provide a reasonable accommodation to these individuals. It's no different than any other medication that may be taken for an underlying disability. New York is one of the states that does classify the underlying condition as a disability. It does equate it to a disability under its human rights statute. So if you are in New York, you should consider the revelation of a medical marijuana card to be a request for the reasonable accommodation of using marijuana outside of the workplace. In Nevada statute does provide that employers must attempt to provide that reasonable accommodation the user's needs outside of the workplace, as long as the accommodation would not pose a threat of harm or danger to persons or property, or impose an undue hardship on the employer, or prohibit the employee from fulfilling any and all of his or her job responsibilities. responsibilities. And I'm going to be talking about this Massachusetts case here shortly. It is a far-reaching decision, probably the first in its kind. Last year, the Massachusetts Supreme Court did hold that employers must undertake a disability-like reasonable accommodation analysis and the like, and I'll talk about that case a little bit more in depth here shortly. So would you win a wrongful termination in these 3 states? In New York, likely yes. Nevada, likely yes. Massachusetts, probably not. So what about federal laws? I said, under the Controlled Substances Act, possession and use of marijuana of any kind is considered a crime. The Attorney General, Jeff Sessions, characterized marijuana as slightly less awful than heroin use. Just because it is a state law. So, of course, must you be forced to hire or retain medical marijuana users who are violating federal law? So when federal and state law do conflict, the federal law that does prevail. It is very nuanced and it is a difficult legal concept. Of course, if a federal statute that outlaws a drug, and of course we know marijuana is a criminal, it is outlawed on a criminal basis, does it relieve you of a state obligation not to discriminate against an employee because they have actively ingested that particular drug? So let's look at some of this, because many states have what we call a lifestyle discrimination statute. And the lifestyle discrimination statutes do vary significantly from state to state. Over half of the states in the United States have a lifestyle discrimination statute, meaning that you cannot discriminate against someone because they are a smoker. We're talking about smoking cigarettes there. We're not talking about marijuana. That's probably the least, the least restrictive states when we talk about lifestyle discrimination against those who smoke. But we have very broad lifestyle discrimination statutes that say that you cannot discriminate against someone for engaging in legal off-duty conduct. So as long as what they're doing off-duty is considered to be legal, you cannot take action against them, no matter how much you may disapprove of that legal off-duty conduct. And again, they vary from state to state. We have Colorado, California, North Dakota that prohibit discrimination based on any lawful off-duty activity. New York is probably one of our broadest lifestyle discrimination statutes that prohibits discrimination based on any lawful recreational activity. Some prohibit discrimination based on the use of lawful consumable products. This does include New York, Illinois, Minnesota, Missouri, Montana, Nevada, North Carolina, Tennessee, and Wisconsin, and then, of course, the tobacco products, 29 states, and the District of Columbia. So what happens if it is illegal in your state, but it's illegal on a federal level? Does that state's lifestyle discrimination statute restrict you in any way? And that was the case, that was the question that was asked in the Coates versus Dish Network case. In this particular case, the employee had a prescription for marijuana use. Taking it as prescribed, and we know in Colorado recognizes marijuana use both for medicinal purposes and on a recreational basis. He was subject to a random drug test by his employer, tested positive, and his employer terminated his employment for failing the drug test, and of course he was tested positive for the marijuana use. He sued under Colorado's lifestyle discrimination statute, saying that his termination violated Colorado law because Colorado legalized marijuana and it was legal on a state level. It goes all the way up to the Colorado Supreme Court, and the Colorado Supreme Court found that the employer had not violated Colorado's lifestyle discrimination statute, finding that for it to be impacted, the activity must be both legal under federal and state law, and because marijuana use was illegal under federal law, the employer was within its rights in terminating this individual's employment and not violating Colorado's lifestyle discrimination statute. Compare this to the Massachusetts case, and this was a a lot of people were really shocked by this decision in Massachusetts, and I will say that the employer in this case did rely on the Colorado case, as of course, Massachusetts is not required to follow another state, but you can, cite another state's law as persuasive authority. And the employer said, look at Colorado, and they they analyzed this correctly, meaning that the use has to be legal both on a federal and state level for the state statute to be impacted. In evaluating Massachusetts state law, however, the court disagreed with Colorado, and of course, obviously, the Massachusetts Supreme Court was looking at a different statute than Colorado's. But under Massachusetts Massachusetts statute, the court found that the employer could not use someone's use of marijuana as a basis for refusing to hire someone. In this particular case, she had the plaintiff. She was fired after her first day working. She was hired to promote products in a supermarket for advantage sales and marketing. She was hired in 2014. Her drug test came back. I'm not quite sure why they put her to work before they got the drug test back, but her drug test came back. Obviously, on her first day of employment, she's called into the Human Resource Department, told that she did not pass the drug test and that the company would follow federal and not state law, and they were therefore going to terminate her employment. Now, what was she taking the drug for? Well, she suffered from Crohn's disease, which is a gastrointestinal condition. She had a written certification of her condition from her doctor. The court found that she did not use marijuana daily, nor would she consume it before or during work, and this was all in the court documents. So, of course, she filed suit, and she claimed that the employer had violated the Massachusetts Medical Marijuana Act that the Massachusetts legislature had passed in 2012. This particular act did state that qualifying patients should not be punished under state law for medical use of marijuana. The court, however, disagreed. The court found that her termination violated the Massachusetts Medical Marijuana Act, noting that one generally should expect an employer not to interfere with the employee taking such medication or to terminate her because she took it. And of course, the court here is, saying we don't even buy the employer's logic here. The court was very critical of the employer, stating that by the defendant's logic, a company that barred the use of insulin by employees in accordance with a company policy would not be discriminating against diabetics because of their handicap, but would simply be implementing a company policy prohibiting the use of a medication. I find that interesting that the Massachusetts Supreme Court would even analyze this in comparison to insulin, because there's no question that insulin is a legal drug throughout the United States. And it's really kind of interesting how the court just really completely ignored the fact that marijuana is still considered an illegal drug under the Controlled Substances Act. So let's talk about some drug testing. Of course, you're always engaging in drug testing because you're obviously trying to, make sure that someone is not under the influence. Or you want to ward off the issues about someone who may harm themselves or others because they are under the influence, and that's why you do engage in random drug testing or even reasonable suspicion drug testing. Well, there are a lot of problems here because most of your drug tests, you're using your analysis. I did have a situation with a client a number of years ago that was undergoing a significant hiring. They were opening up a large hotel in Mississippi. They were, trying to hire, 700 to 1,000 people all in, one occasion. And they were actually doing their drug tests by hair samples. And they had to back off of that because obviously something that is in your hair, it's in your hair for a lot longer than it would be in your blood or your urine. And they learned that they were disqualifying a significant number of individuals because they simply, because people simply could not pass the drug test dealing with the hair samples. But most employers, whether it be because of that practical reason or the cost, usually do drug testing by your analysis. And your analysis, as I stated, they're testing for metabolites. So it cannot determine when marijuana was ingested, whether it was greater than 30 days. Of course, it is testing those metabolites, and therefore it cannot test the level of impairment, unlike alcohol. So it cannot test whether someone is a chronic or acute user or the like. So let's also talk about some practical problems with the use of cannabinoids. And these are those Schedule 2 and 3 drugs, if you will. They are known as K2 or spice, but they're usually not included in routine drug tests due to the need for specialized, expensive testing. So there is a great variation between the products. So you do find difficulty with identifying what metabolites should be included in the testing. Now, why is this a problem here? Well, some synthetic cannabinoid users will use the drugs as a substitute for marijuana to avoid the positive drug test. So when they know that you're going to test them, they'll do that pre-employment testing, or that you're doing some other type of testing in the workplace. They're going to go back and use this as a substitute for the marijuana so that they will not test positive for the drug. Studies have shown that most of the users will return to using marijuana once the drug testing period has ended. Someone who was interviewed in this study stated that spice would give you a weed-like effect without the positive test.